You know, in times of disaster, communities really rely on their government for support and protection, and rightfully so. However, there are instances where the government's actions may inadvertently or otherwise lead to additional heartache and challenges for those already facing adversity. The aftermath of the devastating fire in Lahaina, combined with the looming threat of eminent domain, raises concerns about the future certainty and security of residents who have lost their homes. The hugely controversial 2005 Supreme Court case Kelo versus New London and the dissenting opinion of Justice Sandra Day O'Connor highlighted the potential misuse of eminent domain. So what is eminent domain? Eminent domain is a legal concept that grants governments the power to seize private property for public use, provided the owner is fairly compensated, which is an entirely separate and obviously necessary conversation, but for another time. The purpose of eminent domain is to facilitate the construction of essential public infrastructure such as roads, bridges, schools, and of course here in Maui, we saw the application of eminent domain with the Lahaina bypass. However, the interpretation and application of this power have evolved over time, leading to some controversial cases that challenge the balance between public interest and private property rights. One such example was when the city of New London, Connecticut sought to take private properties through eminent domain for the purpose of economic redevelopment. The decision was split, and not in a good way either, for New Londoners or Americans anywhere. There was a 5-4 majority ruling that the city's actions were constitutional, given that the intended economic benefits could be considered a valid public use. In other words, if the state thinks it can make more revenue from the new owners than the old ones, then it's out with the old and in with the new, making this ruling the most erosive to the constitutionally protected rights since the Patriot Act. Justice Sandra Day O'Connor delivered a powerful dissenting opinion expressing her concern about the potential misuse of eminent domain. She argued that the decision distorted the fundamental purpose of eminent domain, allowing governments to prioritize private economic interests over the rights of individuals and families. The recent fire in Lahaina has left many residents without homes, dealing with the heaviest blow to the community in history. While the immediate focus should be on providing aid and supporting those affected, the specter of eminent domain casts a very dark cloud over the already overburdened lives. The combination of our vulnerable Lahaina residents and the potential for economic interest to influence government actions creates a very concerning scenario indeed. If you're anything like me, you would think that the states would react to this landmark decision by tightening up their own constitutions and improve laws to fill the gap in protections left from the ruling to better protect their citizens, and you'd be right, as many states have done just that. So how does Hawaii stack up? Well, unfortunately, Hawaii's amendments in 2008 did little to nothing to prevent the potential misuse of eminent domain for private economic interests. While the amendments may have aimed to establish stricter guidelines for the use of eminent domain, they did not go anywhere near close to ensuring the interest of the residents were adequately safeguarded, adding only that property owners can challenge a taking if its purported public purpose is pretextual. In other words, you'd have to prove your home was taken under the auspice of public purpose but used for private purposes. Either way, This woefully neglects the fundamental function of government, which is to protect its citizens. This lack of comprehensive protection leaves the communities like Lahaina exposed to the very real threat of losing their homes to development projects disguised as public use initiatives. When taken together with Governor Josh Green's July 17th emergency proclamation that gave himself supreme dictator status under his own emergency proclamation, which should be repealed immediately, leaves very little in terms of legislation to advocate or litigate on behalf of those who have lost so much already. In conclusion, the aftermath of the fire in Lahaina has unveiled a concerning possibility for the displaced residents: the misuse of eminent domain. The Kelo versus New London case serves as a stark reminder of the power imbalance between private property owners and governments driven by economic interests. Justice Sandra Day O'Connor, her dissent underscores the importance of protecting individuals and families from the potential abuse of this power. She notably stated that the specter of condemnation hangs over all property. Nothing is to prevent the state from replacing the Motel 6 with a Ritz-Carlton, any home at the shopping mall, or a farm in the factory. Hawaii's response to the Kelo decision, reflecting its 2008 amendments to eminent domain laws, falls desperately short of providing adequate safeguards against the misuse of eminent domain. As residents strive to rebuild their lives after the fire, it is crucial that both local and national transparent discussions take place to ensure that eminent domain is used sparingly, responsibly, and fairly, especially safeguarding the rights of homes and legacy of those who have already endured so much. The specter of eminent domain must not be allowed to cast a shadow over the lives and the dreams of Lahaina's residents. My name is Ethan Shelton. Thank you for watching. Feel free to grab the attachments and let me know what you think. Do Maui property owners have a reason for concern, or are we just making too much of things? And if we're not making too much of things, what do you think the implications are for the rest of the country? Aloha.